you for joining us tonight. Today looks like tonight, but this is being co-hosted by the Law Book and also the Association of Corporate Counsels Houston chapter. We have a great partnership with them. As you can tell, the weather prevented Mr. Werner from making it here today. That background is artificial. He's actually at the Grand Prairie Horse Track. So, there you have it. He's working on the new Texas. I'm sure he's going to be working on the new Texas, what do you call it? Stock exchange, the Y'all exchange, Y'all Street, whatever they call it. So thanks,
Y'all Street.
That's what,
I like that. Clever. Yeah.
we'll see if Bucky signs up. If not, it's doomed. So, but thanks everyone for coming. The CLE credit is right in front of you. I want to thank V&E and Rebecca for co-sponsoring it along with Holland and Knight and Jessica. We've done this a couple of years now, and them together with Eric and a different angle, which I'm going to let Rebecca introduce everyone and go through she'll be moderating, go through the subject matter. But, this is always just a great panel. We have several people that we record it, and you'll see an article on what's happened in the next day, and there'll be a link to the full video. And we have a lot of people that couldn't make it today because of weather. But thank you all for attending. Thank you, Jessica. Thank you, Rebecca.
All right. Thank you, Mark. Hello, everyone. As you'll see, Mr. Werner is zooming in from the Fort Worth Regional Office. He did try very hard to be here. Luckily, I was supposed to be on his flight from Dallas, but I switched to the Von Lane bus at the last minute last night. So I'm glad, because it would have been harder to moderate from afar. So as Mark mentioned, my name's Rebecca Fike. I'm a partner here at V&E. I am normally in our Dallas office, and I was at the SEC for 10 years under Mr. Werner and actually Jessica McGee, who's about to introduce herself in a minute. And now I do SEC defense work, white collar government investigations, and an increasing amount of kind of corporate advisory work, working on risk assessments and the avoidance of working with my former colleagues. I'm going to turn it over to our panelists. Jessica, we'll start with you to introduce yourself.
Good afternoon, everyone. I'm Jessica McGee. It's nice to be here with you today. Thank you, Rebecca. Thank you to the Texas Law Book. Thank you, Sarah, for giving us your time. Eric, I thank you, but clearly you couldn't be bothered to get on a short flight to Houston. So classic government power move. But your presence virtually is acknowledged. So like Rebecca said, I too am former SEC enforcement. I'm a partner at HK, where I chair our SEC enforcement defense team. And Rebecca and I find ourselves in conversation a lot these days. In addition to being a good friend, she's just a fantastic colleague in the bar, and we do very similar work on the other side of the SEC, DOJ, other 3- and 4-letter agencies, state AGs, internal investigations. And I agree, an increasing amount of stewarding boards and management through potential corporate crises, corporate change events, and preparedness to be compliant with relevant today SEC regulations, and to explain to Eric and his esteemed colleagues why they're wrong when they suggest that compliance is lacking. So I'm pleased to be here with you all today.
Thank you, Jessica. And Sarah, we'll turn to you.
Sure. Sarah Morgan. I'm a partner and one of the co-heads of our M&A and capital markets group, and I advise public companies on disclosure and securities transactions and other strategic transactions. And while I think you guys are all lovely people, it's my goal to help public companies spend as little time as possible with you by helping them get good governance, good compliance policies, giving them good disclosure advice on the front end, and making sure that, we're doing everything we can to make it as easy as possible for our clients to educate their organizations on disclosure and compliance requirements, and sort of what SEC is currently focused on, and then try and come up with practical advice on how to implement all of that.
Exactly. I like to think, even though Sarah's never excited to call me, she's glad I'm there.
It's true.
And now we'll turn it over to Eric to introduce himself. And Eric, if you just want to give a little high-level overview for our guests on the Fort Worth office, and anything else you want to start out with.
Well, thank you for that, and apologies to everyone for not being there in person. After spending the maximum amount of time on the tarmac FAA rules required, and thankfully so, that I be brought back to the gate, and I hustled back to the Fort Worth office. I just checked to see what the current status of my flight was, and it is now scheduled to take off at 2 p.m. So we're think I made the right choice to get off the plane instead of sitting there. But thank you to Rebecca and Jessica and Sarah and to Mark and the Texas Law Book for inviting me to this panel. Appreciate the opportunity to answer questions and talk to all of you about some of the things going on at the SEC, the Fort Worth Regional Office, and in our region in particular. For those of you who don't know, I have worked at the SEC for the better part of my career, first starting in DC as an investigative staff attorney, moved down to Fort Worth in 2004, and have held, I think, nearly every position in the commission, including, I believe, janitor and late night copy repairman, to some middling success on those. So the Fort Worth office is essentially made up of about 125 people, about 50-50 split between enforcement and examinations, a little bit more enforcement, and some operations staff. On the enforcement side, we have 25 investigative staff attorneys, and we probably bring about 25 to 30 new case filings every year, a little bit less than half of which are litigated. That's the litigated piece of it has increased over the last few years. Various reasons going into that, and maybe we'll touch on some of those this afternoon. But you know, the docket that the Fort Worth Regional Office covers pretty much checks a lot of boxes across the docket that the Commission covers. You know, if you look back 15, 20 years ago when I joined the office, we were primarily known as an offering fraud, oil and gas type office that dabbled in complex accounting cases. And in the last year, 2 or 3, we have brought you know, investment advisory cases, municipal bond cases, complex accounting fraud cases, crypto cases, just about everything within the Commission's gambit. And that is due entirely to the hard work of the staff who's actually doing the cases. So we've been pretty lucky to hire some qualified people over the last 3 or 4 years and longer. Unfortunately, we're under a hiring freeze right now. We hope to announce our new supervisory attorney at the assistant director level very soon. But other than that, we're sort of in a temporary holding period here in Fort Worth.
Great. Thank you, Eric. So I want to just dive right in so we can use our time and beat up on Eric as much as possible. We're going to jump right in and start with insider trading. I'm sure most people in the audience have heard of the Panawatt case or the shadow trading case, which the SEC filed a little over a year ago. And just really quick overview on that. In that matter, Panawatt, who was an employee of a company called Medivation, he found out in the course of his employment that a larger company, Pfizer, was going to be acquiring his. He took that information and thought, hey, I bet this will make the stock price of other similarly situated targets also go up. And so he went and bought stock in a competitor called Insight. The SEC brought a suit saying that was insider trading. The suit survived a motion to dismiss and ended up going to a jury trial, which just came out for the SEC just a couple of weeks ago. So we want to start there. Eric, how does Panawatt, and there's actually also been an additional kind of shadow trading case filed, although it was filed as a settled action. How does this represent the SEC's expansion of insider trading liability, or does it?
But appreciate that, and as I am routinely want to do, I skipped over my disclaimer, so let me jump in and make that first.
And I said I wouldn't let you forget.
So the views I expressed today in my official capacity as regional director of the Fort Worth office do not necessarily reflect the views of the commission, the commissioners, my colleagues, or other SEC staff. And I'll have that retroactively apply to the earlier comments as well. So it's on video, so hopefully I'm in good shape. So I really don't think that Panawatt and the most recent case, Arista or Bechtelsheim, however you want to phrase it, expands the scope of insider trading at all. I think that the principles that the commission followed are firmly rooted in years of insider trading law. I think both of them looked at the facts and essentially said you can't trade on material non-public information in violation of a duty or confidence, or having misappropriated the information. And if you look at the facts of these two cases, that's exactly what happened. Each trader came into possession of material non-public information in violation of a duty that was established, and then profited as a result of their trades. And now the duty or the misappropriation is where things probably get a little more interesting, and why people are looking at it, wondering and scratching their heads as to, is this a sea change? Is the SEC somehow expanding the scope of its coverage here? But on Panawatt, and we can argue, whether here or discuss whether here or somewhere else, the policies and procedures that his company had were very broad. And would the commission have brought a case if the policies had been narrow? But in the facts of the Panawatt case, the policies and procedures covered, and said specifically, essentially, you can't trade based on material non-public information learned through the course of your work here in the securities of this company, competitors, agents, and a few other words that almost sort of cast a net to almost everything that the company dealt with. And that's exactly what Panawatt did. He obtained material non-public information about a competitor or about a potential deal, and then bought the securities of a competitor. So the internal policies and procedures violated it. He violated that, and the commission moved, and the court decided that the commission was right on that policy. I think the newer case is a little bit even more simple. Happy to get into those facts if you want, but from my perspective, the commission is not expanding its scope. It's staying right in its lane. It has just been given facts that are a little bit unusual that we've applied those policies to.
So you've already jumped ahead on my outline, but excellent work. I'll note that the Medivation insider trading policy said exactly that you can't use information obtained in the course of your employment, to trade in stocks of the company, a competitor, many others, and then, quote, in the securities of another publicly traded company. So it was that broad. Sarah, has the Panawatt case or kind of the interpretation of it affected how you're advising corporate clients, or how has that, changed how you might think about material non-public information?
Yeah, I mean, look, I don't know a single public company that we work with that didn't at least review their insider trading policy last year for a number of reasons, right? The new rules around the 10b5-1 plans, which often get swept up in insider trading policies, and the fact that you have to file it now with your 10K, and anytime something's public makes you want to take a fresh look. But I think this case was a huge part of that, because the decision did turn on the wording of their insider trading policy. And I think that the way that insider trading policies developed, depending on what the organization was, a lot of time people would have extraneous stuff where they're trying to really use it as a tool to educate people about how this might play out. More what I would say educational language than policy language. And then this case happened, and people looked at it, and they, companies became very concerned that overbroad language in their insider trading policy could become a basis and broaden the scope of liability on their employees. And so I think that, as people went and reviewed their insider trading policy, they went through and cut a lot of the extraneous educational stuff, moved that solely to training. And then where they were looking at language like this, like, whether or not trading in the securities of others made a really deliberate choice that's either in or it's out, and we're making this part of our training, because I think you guys would probably think that the Panawatt case was very clear cut, but I mean, judgments about the materiality of information of what's happening at one company on the impact of others, competitors, and suppliers, it's frequently not that clear cut. Those are difficult, judgments to make, and it's going to be judged in hindsight. And so I think, people are concerned about that, and concerned about having anything in their insider trading policy that could, broaden the scope of potential liability on their employees. And I think that this, to the positive, I think that this made people dust off their training modules and make sure that they had current and relevant information in there, and make sure that, they're putting people in real life scenarios and saying, okay, here's how this could play out, because I think those are the most effective trainings. Anyway.
Jessica, in your either former role, Jessica was regional trial counsel as well as associate regional director over enforcement in Fort Worth. So either in your kind of former role where you were in the government's position, or now on the defense side, how have you kind of viewed the Panawa decision, and how have you been talking with clients about that?
So I think it absolutely is a novel case. It will stand as a novel case. Eric,
You're more willing to poke Eric in the eye than I was.
Yeah, and he will poke me back, I'm sure. But
We used to work for him.
But
It's okay.
listen, I think Eric's right. I think Director Graywall is right that, like, in some sense, this is right down the fairway. This is how we've always prosecuted insider trading. You have to have a duty, material, non-public information, and knowledge or awareness, depending on your circuit and the jury charge, when you trade. Those elements are here. I tip of the hat to the entrepreneurial staff attorney and assistant director team that decided to investigate and pursue this case, because it is novel because of the way they used that policy. And the lesson here is companies really need to understand what's in their policies and what they need and don't need to have in their policies, and why. Zooming out more broadly, because in this SEC, and I dare say in the SEC for years to come, anything can be a controls violation, right? Stepping out of insider trading. So if you have a policy and you have an employee that busts that policy, you might have an internal controls issue. So note, to double underscore what Sarah said, you have to read what's in your policies and think about them and understand why you have them. What's training, what's educational, what's really the rule by which our company expects people to operate. But coming back to Panawa, I don't think the staff would have brought this case without that policy.
Really?
I don't think they would have brought the Scheim, however you pronounce his last name, Arista case without the policy language, because it's a safer bet. So when you're sitting around at the SEC and you're thinking, okay, we've done an investigation, what's the evidence, what's our litigation risk? They don't want to file a novel test the waters case when they're going to get blown out of that water on failure to sufficiently plead duty under a heightened pleading standard. So very smart people sat around and said, oh, we can foot our duty in a policy, and we've got that 7 days a week. And they're right. And so tip of the hat, because I think that was a very smart move, but I do think it moves the bounds of what's now fair game, because the commission had never done that before. Now, it doesn't help Mr. Panawa that he learns, because we read this press release and we're all clutching our pearls like, what?
Yeah,
This is new and different. The SEC has gone way overboard. You get into the facts, and Mr. Panawa hears this information, and minutes later, he's on the phone buying short-term expiration, out of the money options,
Within
right?
30
Like,
minutes.
It's some
Yeah.
pretty egregious.
yeah, there's
facts.
some facts
Yeah.
that you're like, well, bro, kind of self-own here, right? And you have the policy language. So it's a perfect storm for a staff that wants to send that message. And then you have this follow-on action, not a follow-on to Panawa, but you have a following action with Arista that's settled, no binding precedent, but this is SEC playbook. Bring a case, win on that case, message that case in settled actions. They're not binding, but we're telling the market, this is not an outlier. We're serious about this. And so I think the market is reacting appropriately. What do our policies say? And some companies now think we have to make sure our policy explicitly prohibits trading in the securities of any other issuer. Other companies are saying, no, we don't. We can bring it in. We can say what we mean and what you're really restricted from doing. I think, but Sarah, I'd be curious your view. Companies are expected to know themselves, know their competitors, know the market. Here in Panawa, the court really focused on like economic realities, market correlations, the fact that this was a competitor. If I think, using my brain, which 47-year-old working mom brain is not what it once was, and I think, oh, I've got some information I'm learning, maybe I use that in my personal investing strategy. Is that against the law? No, but the misuse of MNPI is. So I'm curious, Sarah, your views on, do you think everybody's running for the hills and expanding, running for the hills and constricting policies?
I think they're constricting.
I think so
For the most
too.
part, I think constricting, but when they do their training and they have their conversation, there's a little
Be
bit
aware.
of, there's a conversation about like what's wrong and what's right. And also here's what case law tells you. And to your point, like, would they have brought this case without the policy? Maybe
Right.
not. but you can't be sure. So you don't, like this is, and you look at the facts of that and you're like, okay, this guy learns about this deal 7 minutes later,
Shouldn't have done it.
short-term calls, right? Like that's clearly like an expectation that this is gonna, impact the stock. But you can see other cases around the edges where, it's a tougher call, and it would be a tougher call on whether it's going to actually impact the competitor's stock, and they just don't.
Yep.
They don't want their employees to get caught up in that. And that's not universally true. Some people, some people have kept it, but it's a deliberate, educated choice, and then they are very deliberate about educating their employee base about the risks of that. But I think for the most part, not just on that provision, but writ large, people are constricting the policy to take out anything extraneous that was educational before that might be interpreted a different way.
Eric, how is the SEC then looking at the controls issue? Like in this example where you have, let's say, a company that has said trading in the securities of any other public company is part of their insider trading policy. Obviously, they're looking at the individual trader and there's potential liability there. But I mean, it seems like the SEC is, increasingly looking at companies and their own policies and procedures and enforcing their policies and procedures. How kind of is the staff viewing that, in a case like Panawatt, where the policy itself is very broad?
I think that may be the most interesting question here and it's interesting to hear Sarah's remark that from her perspective, companies are sort of narrowing the scope rather than broadening, because at some point we want to be deferential and make sure if a company's policies and procedures are reasonable and appropriate and they're being trained properly, then great. Like that's what we want companies to do. Will that understanding shift in the wake of Panawatt? That I think is the great unknown. And if companies are actively narrowing the scope, do their policies and procedures somehow turn into something unreasonable? I don't have the answer to that. I don't know if the SEC will bring a case and let a court find out. But I think the default position for the SEC and certainly the Fort Worth office when we investigate those is we ask for those right out of the gate. We want to look at them, and if the company is doing the right things, we get satisfied and then go looking for anomalies. And as all of you noted, the trading here was very suspicious. The timing was suspicious, and in a Arista case, I mean, trading in other people's accounts is not a good look for someone who wants to get away with it or claim that they are doing something legitimate.
I don't think that any of the companies would view themselves as narrowing the scope of what they're prohibiting. They're prohibiting insider trading, right? To the letter of the law. What I'm talking about is a lot of times in a policy, you would see descriptors and things that were a little bit broader than, just almost like a company's interpretation of what scenario might evolve. And you're seeing a lot of that taken out of the policy itself. And it's not that they're not teaching that anymore. It's still in their training materials. They're still covering that with employees. It's just, look, you're filing this policy publicly. Like clearly the SEC is very focused on the extraneous stuff that's in the policy too. So, unless it's something that we're certain of, and we're certain that this is the letter of the law and this is what's required, let's not expressly put this in our policy.
I would be willing to bet, and Eric, you can chime in on this or not, and I will bind the agency based on what you say, that right now there are a number of open shadow trading investigations where the staff is kicking the tires on the premise that they can extract some more settled actions like Arista, where people don't have the money or the fortitude to litigate, and so they're willing to settle on a no admit, no deny basis, not binding, but you're building market inertia, you're sending market message on the premise that Panawatt is the law now. Like we have established that you cannot use MNPI gained from your employer and trade in comparable, so long as maybe there's some economic connection or market relationship, et cetera.
So do you think it's the law whether they define it that way or not?
Yeah, I think great lawyers like Rebecca will say, no, Panawatt rooted the duty in the policy, and our policy doesn't say that here at Fike Co. And the staff's going to say, yeah, but read our summary judgment briefing, read our other pleadings in the case, they crept their theory once they got past motion to dismiss into an agency law theory, which is a lot shakier than I can print a policy and show where you blew through the duty. Well, you're an agent of the company. So I think that there are investigations actively kicking those tires to look for the next best cases. The facts might be a little less strongly favorable for enforcement, and that's how you sort of move the law, right? And I would also say, and Eric earmuffs if this is not happening, if I were working inside companies, and I'm telling my clients this right now, to me, this is a great heartland for the next enforcement sweep. They've spent 2 years talking to us about how fantastic their data analytics are. Between FINRA market surveillance, SEC data analytics, they know who's trading and when. So you say, okay, I want to pull data analytics on these 20 companies. I'm going to go ask their top 5 competitors for their insider trading policies. And then I'm going to do a sweep. I'm going to ask all those companies that gave me their insider trading policies, and I'm going to ask all their competitors for swap information, and you're going to see who's trading in like companies. That is what we call a stat juicer, right? That gives a regional office or a home office great numbers to say, look at all these actions we brought in the fiscal year, right? So to me, this is here to stay, and it's kind of scary, and it's Eric Werner's fault.
Well, I mean, but I think you make an excellent point, because I think one of the most compelling things you can say in a company training is just explaining how these data analytics work, and that you're not gonna, whatever you're doing, right? If you're listening to us and you're like, like this is great, like maybe I'll still do some trading on the side. Like, you're not gonna outsmart the
No.
data analytics.
No.
And so understanding that and understanding how refined and advanced they are, and the multiple ways that they have to catch trading patterns, like when you make people aware of that, and it's something around the edges, I think people are just like, not gonna mess with that.
Takeaway today, insider trading, don't do it.
Don't do it. Don't do it.
Which is so new and novel.
Yeah, I mean,
Eric, any response there?
No, okay. There was a lot here, and at the risk of spending the entire hour talking about insider trading, as you, Rebecca, and Jessica know how we obtain potential leads. I mean, there are FINRA random folks giving TCRs, there are SARS and DSA filings, and we're working backwards. And neither one of the cases we've discussed this morning came from the Fort Worth office. So I don't have the inside knowledge as to how it came about, why they decided, whether there were pivot points where they said, should we not proceed? But having worked on these investigations for the better part of 25 years or so, that's generous. There are things that we look at, and when you see out of the short-term, out of the money options that are very profitable, okay, maybe we look a little further. When we see trades in relatives or associates accounts, maybe we proceed a little further. It's those types of things that don't come in the door for us that we obtain as we go forward with our investigations that make cases look interesting. Your potential sweep, Jessica, is interesting. I'm gonna have to chew on that for a little bit.
that was earmuffs, man. That was,
Gave him a great idea.
Again, as you know, we
Future
have
defense
a
work
lot
for
of
you.
other work to do at the SEC. So I don't think you'll see anyone devoting all of their resources to insider trading. We'll have to see in 2, 3, 5 years whether that came to bear fruit.
One thing, and we will move on from insider trading, but it is my favorite topic. One thing I have, in talking with companies and with Sarah, is if a company does have that slightly broader definition of insider trading, if it is in, the shares of any other publicly traded company, one thing I think companies need to really look at is their internal policies and procedures, and how are you monitoring and enforcing that insider trading policy? Because if you say that's what insider trading means for your company, one thing as your potential future defense counsel that we're going to be talking to the SEC about is, how did you enforce your policy? And while certainly you can't stop a determined bad actor, you can make sure that you're, surveying, that you're educating properly, because you, the company, have some obligation there to enforce your own policy, because the SEC is certainly going to be asking you about that. And with that, we will move on to, unless anyone else. Okay. So moving to disclosures, my other favorite topic. One thing I've noticed, at least on the investigation side, I don't know if we have as many kind of public examples of these matters yet, but as ESG and other topics have become so frequently discussed, I've noticed that the staff has been looking at and focusing more on kind of the narrative part of a company's disclosures. So we're all very used to the idea of having like a backup binder, a tie out for any numerical or quantitative statement you have in a filing. Increasingly, I'm getting questions in investigations about, show us what you have to support X, and X is a sentence, something that's more descriptive, something about the company, something about the company's priorities, its plans, its goals, et cetera. And so I kind of wanted to start there and just ask Eric, how is the SEC enforcement, thinking about these narrative, more qualitative disclosures? What should companies know?
From my perspective, what does the company itself think is important for that company? What makes it stand out? What makes it successful? What is the company deciding to highlight in public statements, mission filings, earnings reports, things like that? And at the end of the day, it may ultimately be material, but if the company is putting something front and center saying, we are great because of X, and then we go and look and find out that you aren't doing X, that likely will be considered material from the SEC standpoint. And the SEC has brought a number of cases over the last 5 to 10 years with just that analysis. And I think that is a perspective that at least I have taken, and I think the Fort Worth office has taken when we sort of kick the tires on some ESG cases. Ultimately, if a company thinks that they should be considered for their carbon neutral policy or who their suppliers are, but yet they're not doing those things, okay, like that seems like it's significant to us. And, sort of overlapping with an issue that, covers cooperation that we might cover a little bit later, and the sort of inability of the commission to announce or discuss cases that were never brought. Of the ESG cases that we opened and investigated, we have not brought one. We thankfully have found companies in our region that were doing what they said they were doing. And that is great to see. And so we closed our shop and moved on.
That's because Sarah was there.
I would say, look, anything that isn't within the four corners of a 34 Act report is heavily scrutinized by multiple people and usually multiple layers of review. And people are very careful about that. And I think over the last 2 to 3 years, both with the, proposed climate rules and that everything that's coming around that, plus the ESG and anti-ESG backlash and all the increased focus on sustainability reporting and greenwashing, I think now that the same level of attention is given to anything external to your 34 Act reports, like corporate and sustainability reports. But I don't even think, like, even before that, when they were a little bit more loose, I don't think people were necessarily misrepresenting what they were doing. It was just something that was written so broadly and loosely that it could make it seem like maybe perhaps something a little bit bigger of an endeavor than than it actually was. And now I think people are a lot more precise about it, a lot more precise about the risks around any of those strategies too, just as people have focused more heavily on that. But I think people have always paid a lot of attention to their narrative disclosures and continue to do a really good job around that.
Jessica, what have you seen in this space?
First, I want to note that there's thunder roll anytime you speak, which is an amazing moment. And I want to be you. That's amazing. So I think I agree with everything Eric and Sarah both have said. And I think you can take it out of the ESG space, right? And we all find ourselves saying ESG itself is not a monolith. It's can be a catch-all, I suppose. But I think the SEC has always expected issuers, regulated entities to know themselves, right? We're a principles-based disclosure more than a prescriptive-based disclosure regime. And it's know yourself, you know yourself best. And to your point earlier, what's material. I think what I'm seeing most recently in the disclosure-focused investigation space is a heightened focus on specific, I'd say closer to definitive words, words to describe accomplishments or state of business, or even what we might call forward-looking language, but where you're being more definitive. An example that we always use coming from the SEC is when you say, oh, this may happen, and in fact, this has happened or will happen, right? That's an easy thing that you should be able to go through with your counsel and team every time you're checking disclosure for currency to make sure may is still the case and not will or has. But I also think more specific jargon, industry speak, highly technical speak. So, you know, we're an EV company and we're going to say something about what's going on with this new vehicle that we're developing and where we are in that process and where we expect to be. I think there is, and appropriately so, an increased regulatory focus on, as Eric says, understanding what they're saying and kicking the tires to make sure that you can backstop what you've said. I will credit the Fort Worth office, which I'm not famous for doing, with being one of the, I'd say arguably the most practical office in terms of the professionals that handle investigations being as candid as they can be. We will talk about cooperation and collaboration. I do not mean to say it's a two-way road, but where I think the culture of that office is that group investigates to get it right, not to drop the hammer. And so if they're focusing on a disclosure issue, if it's, you know, there's room for reasonable minds to differ, I think there's also room for reasonable minds to have that discussion with the staff. Eric said they've had instances where, and you don't see this because they don't report stats on closed cases, they've kicked tires on a disclosure. They found that the company had a reasonable process, a basis for what they've said, and the SEC has moved on. That, in fact, is justice. That, in fact, is the regulatory oversight process working. And I credit the office for that. I will also say I have cases in that office and other offices where we're really spending a lot of time sort of like what the definition of is. And that can be very expensive, right? I mean, we're talking about months, if not years, of companies trying to proffer information, collect documents, go look at emails, think about things that were decided by people that don't work there anymore to get into like why a word or words were selected. And that can be very hard, and it can lead to a very murky outcome where maybe you settle just to make it go away versus the right answer being arrived at.
I think I would agree in that I have found the staff to be, I think, as transparent as they can be, where they have a hang up with certain language, you know what it is. We might disagree on whether that hang up should be there, but you understand what they're looking at and what it is you need to try to convey in order to have them kind of understand the point of view of the company. I find them mildly less reasonable now that I am not there, but that's just, I guess, a burden of leaving. But Eric, one thing I'd love to get your thoughts on is how does the staff think about materiality in those contexts?
So it's a little harder. And I know when we were prepping for this, we were talking about materiality in the insider trading standpoint, but also materiality in the sort of narrative side. Materiality in insider trading is a whole lot easier. I mean, it essentially comes down to, did the market move when the news was released? And, you know, I have sort of suffered some slings and arrows on that and investigated a case that checked every other box, but the market never moved, and ultimately we closed it. But, you know, the thought of, you know, out of the money call options and trading in other people's accounts and doing it immediately, it had all the earmarks of someone who intended to violate the law, but ultimately we decided we would never win on materiality. So, okay. You know, at the end of the day, the person didn't make any money, so we thought it was an okay resolution, but it still sort of sticks in my head as something that, you know, you have to understand the law before you move forward and make a recommendation and file a case. On the sort of narrative disclosure side of things, materiality is a little different, and I go back to what I said a few minutes ago. If the company thinks it is material, if the company thinks it is important, it is worth mentioning publicly, then likely the commission will find it material as well. And oftentimes we have conducted investigations where maybe a whistleblower has come to us and said, my company is manipulating metric A. And the first thing that we do is go look at recent public statements to see if metric A was discussed. And if it wasn't, then we have a much more difficult time deciding whether to devote resources. But if it is front and center in every earnings report and 8K and 10K and Q, okay, maybe we will have an issue there. But it is not easy. It is more art than science. And ultimately, that is a determination we have to make before we decide to recommend an action to our client and whether to file it.
Can I jump in on that? I totally agree, Eric. And I would say playbook for companies that are, one day might be responding to an investigation is when the staff's sitting around thinking about, okay, we've got a disclosure violation potentially, how we're going to prove materiality. They know how they're going to prove it. They've already gone out and talked to a couple investors in the company, right? And likely not institutionals who had counsel and maybe had a little extra diligence, but like retail or close to retail investors who would say, yeah, this mattered to me, right? The standard is, would it matter to a reasonable, prudent investor in the total mix of information? That's not that hard a standard. And then when you put it in a civil context of preponderance of an evidence, you can find someone that you can put on the stand to do that. And if for some reason you can't, you can sort of roll the dice and call an issuer representatives. We've done it. Historically, when I was at the SEC, we would do it with CEOs, with former employees that might have a scotch of disgruntled feeling about the company, and call them as an adverse witness in the SEC's case in chief to say, you put, exactly to Eric's point, you put it in there because you thought it mattered to the reader. It's really hard to back out of that. And so you can essentially get to materiality. You hear people say like DOJ can indict a ham sandwich. SEC can establish materiality, right? If you find yourself in a disclosure investigation and you're negotiating or even responding to a Wells notice, which is when the SEC says, hey, we're planning to recommend you or your company be charged, you're not going to do great if you're arguing something wouldn't have mattered to a reasonable investor. And Eric sort of touched on this as well. The best thing you can do in a situation like that is find another basis to credibly persuade Eric and his colleagues why they're not going to win, or at least why you're a credible litigation threat. That is always going to be more meaningful in that discussion than, it's not material, right?
We disclosed it. Yeah.
Or we disclosed it, yeah.
But yeah. All right, switching topics again to off-channel communications. This has been a very hot area in the defense bar. I'm curious, in talking with Sarah, kind of how much it's being talked about just sort of in business day to day. But general idea is the SEC has recently had several sweeps, generally so far for broker-dealers, registered investment advisors, saying that these entities are not retaining off-channel communications like texting, WhatsApp, anything that's not an official business channel that the business is already regularly maintaining, because those registered entities have obligations to retain records. And what's interesting is in these cases, for the most part, the SEC doesn't have to show that, a specific message that they know is relevant could not be provided or was not provided. They just have to show that employees were communicating about business in these forums and the company didn't save them. And there doesn't need to be an underlying violation. There doesn't need to be some kind of fraud action. It's a record keeping violation. Now, it can be added to cases where those other, elements exist. But if you are a registered entity and you're not retaining, let's say, an employee's text who routinely is texting with their supervisor all about work, that can be a violation in and of itself. And so, sorry, I got carried away on my story of why companies have got to start retaining these things. But Eric, so far it seems like these cases have largely been in the regulated entity space. And wondering, is this something that public and private companies, which may more relate to our audience, that they should be thinking about also?
To some extent, yes. Obviously, the record-keeping obligations are different. Registered entities and persons have specific record-keeping obligations set forth under the securities laws, whether it's the Exchange Act or the Advisors Act or a few other places. Public companies also have document retention requirements, but it looks a little bit different, and it oftentimes flows through other gatekeepers. What financial records need to be retained for an audit? What are the company's internal policies and procedures? What does the IRS require? So to the extent that a company doesn't have a set of records, we might scratch our heads and say, why don't they? And do they have an outstanding obligation under some other regulatory regime to maintain those? Because there really aren't that many. There are some under the Exchange Act for publicly traded companies, and then even less so for private companies. But the way I've looked at it is, and as we discussed before this meeting, when I started the commission way back when we were conducting an investigation, we had paper, we had phone records, and we had witness statements. that was essentially our evidence in trying to determine whether someone violated the federal securities laws. Now there are scores of mechanisms or platforms for people to communicate, and we want to find out what the communications were, hopefully contemporaneous communications or after the fact communications that may develop scienter or provide another basis for an understanding of the conduct that took place. And if that was through WhatsApp, if that was some other quote unquote off-channel communication, we want to, if we can, obtain that, review it, and have it help develop our understanding of what took place at the time. And if a company doesn't have those, or individuals don't have those or deleted them, we may be backed into a corner. There may be no obligation for anyone to have retained those, and now we are stuck trying to build our case under other circumstantial evidence. But the world we live in right now, we are going to ask for it. We are going to try to obtain it. And even if it doesn't seem like it's called for under our subpoena, we are taking trainings to figure out how to draft subpoenas. We're talking to our Office of General Counsel to figure out how best to capture those types of communications when we send a subpoena. And then how do we download them? How do we review them? How do we reach other providers and within the various laws for maintaining it by third parties? So, it's out there, it's real, but I think it looks materially different than it would for a registered entity.
So what I'm hearing is for public companies, auto delete could be their friend.
Well,
Sarah, what are your thoughts on
yeah,
that?
I think people have been focused on corporate communications for a number of issues, not really because of SEC enforcement, because to your point, they look at you guys like you guys are focused on banks under the broker dealer laws, but the DOJ got people's attention last year when they clarified that they expect all companies to maintain and enforce policies around business-related communications, and we're very specific that meant, ephemeral messaging devices, and honestly, also that the FTC active in the space, and so if you're in a situation, an M&A situation, and they're doing something or some sort of inquiry or some kind of other competitive inquiry. They expect you to preserve those communications. And I think people for their own internal reasons have been further developing their policies around what can and cannot be used for work messaging, and being careful to, in some instances, only approve platforms where the IT department can control the data retention policies, or have a policy around what that needed to be. So I think people are focused on it. But rightly or wrongly, not because of the threat of SEC enforcement. They're focused on it for other reasons.
On a practical
yeah.
note, I mean, you can have a company saying, you can only use like our Microsoft Teams chat, and yet, at least I know often it's more text and other places that people communicate more. I mean, are you seeing clients trying to grapple with that? Are they just kind of putting a policy into place and, you're hoping your employees follow it? How are you seeing companies kind of handle the practical application of that?
I think a lot of people have their own sort of internal,
Mhm.
just like we do our own internal chat platform, and encourage people to use that. And then have, again, if you're using something else, have a more specific policy around that. Either say we need to be able to control that, or, if you're a little bit more lenient, say, okay, you can do this, but here's what the data retention on this has to be. And then particularly if there's any kind of investigation, sort of immediately as part of the preservation notice, say, this is what this means for, all communication channels, not just email and, whatnot. And then, but I do think that this is something where, companies, at least the ones that we work with, have done a good job of doing trainings around this, around, what's discoverable, what's the concept of privilege, and all of these things, like what are protected communications, what are discoverable communications, just making people realize the way that this would come up in any sort of investigation or a case. So I think people do a good job around that.
Jessica, what are you seeing?
I have so many feelings on this topic. I mean, it makes me miss being at the government, and you just can be really creative about what you're going to subpoena, and you're going to go subpoena it. And if it's an investigation, the other side's not going to quash it. and you're gonna win if you file a subpoena enforcement action. So go nuts. And I don't actually think the staff goes nuts, but they're going to follow the evidence, as is their job. And it's just so incredibly expensive. And the staff are not trained, I don't think, to take into consideration the impact and burden and expense, not to speak of privacy considerations, that companies have to consider when they get a subpoena with a 2-week turnaround and, we're going to give you an extra 2 weeks because we're nice guys. But also, so I just have a scattershot set of points. Another one of which is, go tell the CEO, don't text about business.
Yeah.
Go tell these public company directors who are sat on 6 different boards and some of whom have full-time jobs and have seen a lot more than this girl has seen. Don't text with the other directors. You need to have a company dedicated email that you log into every single time we send you a book. You know what they're going to say? It ain't going to be pretty. They're not going to like it. And the GC, the outside counsel, the CFO, whoever's delivering that message is going to immediately lose credibility with those executives and those directors. So we have to deal in a real world environment. The SEC does not. And our job as defense counsel is to be the bridge to help the staff, who I think are operating in good faith and doing their best job to protect the market. But it's our job to socialize to staff everything that we can do, but everything that is not reasonable to do, right? And again, and I'm such a broken record, it really comes back, I think, these days to policies and starting from a premise of readiness. Company, what does our policy say? Are we giving people phones? Are we reimbursing them for their phones? What are our rights in terms of snagging data from someone's phone if we need to? Are we able to preserve something that's on someone's device as they're out walking around in the world? Or are we not? And if we're not, and if we find that CEO Jane was texting with Director Sally, is that a business communication or is that a personal communication? And those are going to be hard conversations, but companies going to have to establish a tolerance around that to communicate internally and communicate with the regulator. And so you have to invest in these things now. You have to tabletop and prepare for those things now, because the sun may be shining, but a rain cloud of the SEC or DOJ or a state AG's office may enter the atmosphere, and you do not want to be caught on your heels with these things. And when you're in litigation, the rules say you got to take reasonableness and expense into consideration. That is not in the playbook when you're dealing with a regulator, and they are not expected to stop because you've met your tolerance.
I think that's one of the biggest things is, saying that it's an uncomfortable conversation or, or one you're probably not going to have with your CEO to say, don't text about business. Well, even more uncomfortable is your defense counsel is saying, we're going to image your phone because the SEC gets to see all of your texts about business. That is, then in many of those conversations, is also very uncomfortable. I mean, texts are personal. You're more off the cuff there. I certainly would never want mine blown up on a screen, and I've been an attorney for 15 years. But I think what's hard is, generally in regulatory investigations in the SEC, you don't, or you can't redact for privilege or not, sorry, you can redact for privilege for relevance or kind of personal things. Like generally, if you're, using your
or even
corporate
company
email,
confidential information.
Exactly, a company confidential information. What's hard with texts is I think the world of personal and business is so interwoven that I do wonder if at some point there might be more tolerance for that, because that's what gets really challenging in getting executive texts is you've got in the same thread, because oftentimes their fellow C-suites are also friends, and you're chatting about, in the same long thread that maybe in an email world would have been separate email chains, and one would have been relevant and produced and one wouldn't, whereas text threads don't have a nice, easy break point. It is just a really challenging world, and I would never want, my company's leadership to find out their texts are up for grabs when they are at that moment being grabbed.
I think the best advice is still pick up the phone, right? Or
Gosh.
have a conversation. And then, to the extent you recall it, truthfully describe it if you ever have to. That's hard with the speed of information and the amount of business decision that has to be made. But I think your advice is spot on. If I were back on the staff, though, I would do exactly what Eric's saying. I would subpoena every form and place that a communication can exist or be retained possible, because as we're all trained, fraud doesn't occur over email anymore.
Not anymore.
People got smarter. And so now when we're searching for fraud, we're looking for things like take offline, call me, text me.
Mhm.
Okay, then you're gonna go figure out, where did they go when they went offline? Oh, they went to their Instagram messages. Oh, they went to their Facebook messages. The really scary proposition is when they're communicating on their other, like, directors or executives who are on other public boards, when they're communicating over those third-party servers, and you've got to notify those third parties that you possess material I now have to produce in response to an SEC subpoena, a grand jury subpoena. Problems, right? So I think we find that scared straight exercises are great exercises with boards and with managers.
I will say one caveat to that. If you do take something offline, if there's a problem identified at the outset, there needs to be a written wrap to that.
Yeah,
And
great
as
point.
we discussed, this is not a problem because.
No fraud here,
X,
guys.
Y, Z.
Yeah.
'Cause
Yeah, great point.
we've seen we've seen those be problems before.
Yeah,
Where it did get,
Yeah.
it did get
Yeah.
discussed.
It's
got
perfectly
resolved,
appropriate to
yeah,
take it
and
offline
just,
because she and I are gonna go get a manicure while we solve the business problem.
Yeah.
But we need to come back online and say,
Yeah.
great manicure, no fraud. I totally agree. It's a great point.
Great hour of work there. I mean, because I think one of the problems is I understand why the staff wants these communications because I mean, you get employees, high level employees chatting back and forth with each other while there's maybe a CEO making a public statement. Well, if I'm a staff SEC enforcement attorney, I'm really interested in what those, informed employees are commenting on the public statements your company is making. Those are, when I was on the staff side, text messages were the most fun thing to read. But it is challenging from the volume, expense, time period and privacy, concerns.
Eric, what would you say, if you don't mind me hijacking for just a moment, Rebecca, when you have defense counsel who are otherwise cooperating, right? They're not slow playing, they're not obstructing, they're engaging in the process, but they're saying, look, this is going to be too expensive, or we can't get those devices, or what if we image them and hold them and you see if you need that material later? Like, are there tolerances for those kinds of conversation? I have to imagine there are, but how do you approach, or how does your team approach those issues?
Yes, there is tolerance, and I think this is where building a relationship from the outset is beneficial for everyone, because if there is credibility that has been established, and if counsel is working with us sort of in the same direction, obviously there are differing interests at play, but if there is a reasonable request made, and there are requests made all the time, but whether they're reasonable or not is what we need to decide. And look, it also depends on the type of case, facts and circumstances, but I get it. I get that the SEC wields an incredible amount of power, that as all three of you have said, some of the things that we do in our investigations can be very expensive for your clients. Our goal is not to bankrupt anyone. Our goal is not to make life difficult. Our goal is to decide whether someone violated the securities laws. And if that requires us to go ferret out off-channel communications because a director talked to someone over words with friends, then we might have to do that. But getting to that point can be time intensive and ultimately costly. So to the extent that some of those issues are raised beforehand and flagged, we are willing to listen to that and try to be as reasonable as possible.
I think what's particularly challenging is just that the volume of output we now create every day is so high. And so it both speaks to the staff side, which is this is relevant information that's been produced and I want to read it. And then from the company saying, maybe 10 years ago you produced X amount of data. I mean, now that is at least 10X, just the amount. I mean, I think about the emails I send in just one day and texts and everything else. And, I don't know what the solution to that is, but it's always good to hear the staff is open to reasonable offers.
Well, it sounds like that's cooperation, right?
Right.
It's engaging and saying, look, if you think there's a problem, tell us what you think it is, and we really will go look for the facts around it and bring them back to you so that maybe we can separate the wheat from the chaff, or at least the noise from the signal, which reduces expense and I guess can reduce investigative life cycle, maybe?
I would think so, because the volume is also a problem on the staff side.
Yeah, fair.
All right. Well, we are only halfway through the number of amazing topics we could all sit here and bug Eric about, but we've reached our hour and you've earned your CLE credit, and I'm sure everyone has to get back to work and I have to get back on my bus. So I'll just say thank you everyone so very much for coming. You were a great audience. Thanks those who could join online. And Eric, thank you. Even if you couldn't quite get here in person, thank you for appearing
Eric.
on our screen.
Well, I appreciate that. I said the only upside, and if I forgot that I have my St. Louis Cardinals bucket behind me, maybe the only saving grace is I was planning on maybe going to the Astros Cardinals game, and maybe I don't have to sit through the Cardinals getting thumped one more time by the Astros, so I can actually do some work. But thank you all for the invitation and the opportunity to talk to you, and you know, no real closing remarks, but given the time, but to the extent that any of you have any questions about the Fort Worth office or the SEC, you know, feel free to give me a call or shoot me an email. You know, we want to be as transparent about how we do our work to the extent we can, given the non-public nature of it. But I think understanding sort of how some of our investigations are conducted, sort of what we're looking for, can be helpful. And look, at the end of the day, we want to be partners. We want to protect investors, but we want to be partners with those folks in our region so that we can build a relationship and then focus on people who are actually doing really bad things. So that's sort of where we stand. And again, happy to talk to any of you offline.
I don't want to take away anyone. If you prepared closing remarks, please.
No, I mean, I
Feel
think
free.
exactly what he said, I mean, is very much appreciated by issuers. Because look, you know, if you're the general counsel or within the legal department of a public company, this is, you know, the compliance obligations, disclosure obligations, that's only a fraction of the things that you're dealing with on a day-to-day basis. There's a lot to stay on top of. And so the less you have to guess about what the SEC means by something or what they're looking for or what they're focused on, you know, you can kind of just cut right to the chase and say, okay, like here's the important stuff that we need to be doing in this space, and then, you know, move along to the next thing. So you know, I think people appreciate the forthrightness and, you know, and transparency. And you know, and it's helpful to everyone to, you know, most companies do not want to violate securities laws, so they're trying really hard not to do that. So the more guidance they can have on that, I think the better. Agree.
Yeah, and I would just underscore both of them, and especially say in the Fort Worth office, I mean, I've seen Eric put, what do you put your money where your mouth is, or your mouth where, you're probably not supposed to make those things touch, but
Yeah.
I have seen Eric live the value he was just describing. David Frazier, who runs enforcement, Keith, who runs trial, up and down the office, and from side to side. They do mean it when they say, pick up the phone and reach in. It shouldn't be a scary proposition. Do it through Rebecca, through Sarah, through me, through your trusted counsel. But more information is always a good thing. And it does put, I think, everybody in a better position to identify and weed out the actual bad actors and let good faith operators keep doing business where perfection is the goal, but not the standard. And I think at least we get to operate in a region where staff understand that. Thanks, Eric. Thanks,
right.
Lawbook. Thanks, Vianney.
Thank you.
Thank you.